Good morning, you all. Am I audible? Welcome to this first session of the day. The first session will be law relating to succession, intestacy succession, and testamentary succession. Now, you all are judicial officers, so I take it that so far as this legal provision while pursuing law and thereafter while deciding cases, you have come across these sort of matters. Now, to briefly segregate, we have two broad categories. One, the academic part of the acts, which we study while we are pursuing our legal course. When you join as a judicial officer, then you are put into the practical intricacies of this law. Now, in India, as it stands now, we have the Indian Succession Act 1925. This Succession Act, except in case of the state of Jammu and Kashmir, has been made applicable to rest of India. Now, in respect of Sikkim, there are some departure so far as the Succession Act is concerned. This departure is because of the constitutional mandate under Article 371H in respect of the Sikkim. Now, you will find under the Indian Succession Act, Section 3, the state legislature can also, by notification, restrict the implementation of this act in respect of certain races in the state. If you have the Succession Act, kindly refer to Section 3. Now, digressing from this aspect for the moment, we can now straight away come to the testate and intestate succession in case of a person. What is testate succession? Where one leaves a document expressing his desire as to how his properties after his death will pass on to others. And the other is intestate succession, where a person does not leave behind any document specifying the mode how the properties of him will flow after his death. Now, intestate succession is in respect of particular person dependent on their customary laws and also codified laws. We take an example of the Hindus. Right from Manu Yajnavalkya, these Upanishads, these books had from time to time laid down how the succession will take place amongst the Hindus. Now, after the advent of the British regime in India, the British government found that in respect of the succession in India, due to its diversities, some codification is required. But it did not come on one day. It gradually concentrated into the passing of the Indian Succession Act, and much later, in 1956, after independence, the Hindu Succession Act came, which codified the succession amongst the Hindus. Prior to that, the succession was going as per the customary laws of the particular person to whom, to which race, which caste, which creed he belonged to. Now, if we take the Indian Succession Act, you will find the definition of will in section 2, subsection D, subsection H, sorry. Will means the legal declaration of the intention of the testator with respect to his property which he desires to be carried into either after his death. This is what just I have now referred to. Now, will in this definition nowhere says that it has to be a written document, but in the later part of the Act, Succession Act, you will find that will has to be a written document which is to be signed by the testator or the testatrix, that means the person who is making the will. It has to be attested by two witnesses who had seen the testator sign, and after the testator or the testatrix, they have appended their signature. Only then a valid will comes into existence. Now, will does not, under the Registration Act, does not require compulsory registration, but it is optional, and in some cases we found that the document is registered. Now, after the death of the testator or the testatrix who has left behind a will, the application for grant of probate is made. Here I will clarify that in the will, if there is a named executor who is to take the probate, then it is an application for grant of probate, because the executor will be applying before the court and ask for probate being granted in his favor. In case of wills without the executor, no probate application will lie, but it will be an application for letters of administration with the will annexed, because the executor is not named over there. So who is going to obtain the grant? That's the reason a legatee or a person interested who is otherwise entitled to get letters of administration will apply before the court for obtaining letters of administration with the will annexed. There may be also a case where the will names an executor, but it may so happen that the executor prior to the testator or the testatrix has passed away. So there is no executor. In that case also, it will be a letters of administration, application for letters of administration with the will annexed. There may be also another instance where you will find that the executor has renounced his executorship. He was appointed, but he has expressed his disinclination to apply and obtain probate. In that case also, the letters of administration has to be applied. Now, what will be the contents of the letters of administration or a application for grant of probate has been also specified in the Indian succession, that you all know. If you refer to 278 and those sections, you will get it. The next point which comes, that what is the nature of an application for grant of probate or letters of administration. Now, so far as probate is concerned, the Supreme Court has time and again said that it is a personal right of the executor to obtain probate. Before I proceed to the next stage, I will give you another example which may practically happen. An application for grant of probate has been made before any of you. Before the application could be finally heard and disposed of, the executor dies. What will happen then? Because the executorship is a private right available to him under the will as per the volition of the deceased, the application will then be converted into an application for letters of administration with the will annexed and can be proceeded with by any of the legatees of the deceased person. They have to come before the court, pray for conversion of the application for grant of probate into a letters of administration, and it will then be converted as a letters of administration, and the persons who had applied will be permitted to proceed with the application for letters of administration. Now, there is also a grey area in respect of a case where, suppose a person files a letters of administration and before he or she could obtain it, passes away. What will be the fate of that application? The Supreme Court in Shambhu Prasad Gupta 2000 volume 9 SCC has said that in case of letters of administration, substitution is permissible, but at the same time, if the person who has come before the court is entitled to apply on his own right for letters of administration, he should be also asked to apply in his name. Suppose I give you an example. X dies, leaving behind, without making a will, leaving behind, X is a Hindu, leaving behind his mother, his widow, and his son. Now, under the normal devolution of a Hindu, the widow, the son, as also the mother will be entitled to a share in the estate left behind by the deceased. Now, the mother applies for letters of administration. Before she could get it, she passes away. Now, what will happen? 1/3, say in this case, 1/3 share, which was to go to the mother from his son, now will be distributed amongst the heirs of the mother, who will be the brothers and sisters of his deceased son. X, say X dies, leaving behind Y, his mother, A and B, widow and son. Now Y applies for letters of administration but dies before obtaining. Now Y's estate will go to the, by survivorship or by inheritance, whatever will be the applicable law, will go to Y's legal heirs. Now, who will be the legal heirs of Y? The legal heirs of Y will be the brothers and sisters of X. X was Y's son who had died. Now, after Y's death, X's brothers and sisters will get it. So, the brothers and sisters of X, who, due to the presence of the mother, widow and the son, was otherwise not entitled to apply for letters of administration of their deceased brother's estate, that is X's estate, now by virtue of inheritance through Y, has a minuscule right in respect of the estate left behind by X. They have their individual capacity to apply for letters of administration, but they can also apply for substitution in the place and state of their mother to continue with the application for letters of administration which has already been made by the mother. So these are certain practical issues which may arise before you. So I think I have been able to give you a wide overview of these facts. If you have any query, you are free. You can ask me in course, because I will then refer to it and proceed further. Yes, any query in so far as this part is concerned? Be free. No, there is no, we are all discussing on law. It's not that I know thing which is absolutely correct and you do not know things. I may be a resource person today, but law is such vast that even I may be not aware of things which you are aware of, because you have dealt with it. Now, any problem, any question? Yes, madam, any question?
I have one question.
Yes.
whenever there is an application for letters of administration from one of the party, and at the same time there is an application for probate of will from another party, how should we take these two cases? Should we dispose it?
That you have to take it, you have to hear it simultaneously. Because, see, I will come to very good question in this parlance, that I will come to this topic in the next part, immediately now. Now, going by your question, a person, say A, died. Some of others are claiming that X left behind a will, and under which, say, A left behind a will under which X is the executor. So X has applied for the grant of the probate. At the same time, B comes forward and says that A has left no will, he died intestate. I, being entitled to obtain letters of administration, I am seeking administration of the estate left behind by A. This is your question. Now see, if you go by, if you come to section 276, what are the contents required to be stated in a application for grant of probate? Say A, time of death, that the writing annexed is his last will, that it was duly executed, the amount of assets. When the application is for probate, the petitioner is the executor named in the will. In addition to these particulars, the petition shall further state, when the application is to the district judge, that the deceased at the time of his death had a fixed place of abode and had some property situate within the jurisdiction. When the application is to the district delegate, that the deceased at the time of death had fixed abode. Where the application is to the district and any portion of the asset likely to come to the petitioner's hand is situated in another state, the petitioner shall further state the amount. Then you come to the next part. (278) Petition for letters of administration. Application for letters of administration, same contents, same thing, amount, when the application is district, when the application is to. Now, in addition to this, if you come to 279, section 279, every person applying to any of the court mentioned in the proviso to section 273 for probate or will or letters of administration of an estate intended to have effect throughout India shall state in his petition, in addition to the matters respectively required by section 276 and section 278, that to the best of his belief no application has been made. Now, this no application has to be made. So, it is required to consolidate the two applications, because see, ultimately if the will is to be probated, what you have to find out? You have to find out that whether any of the legal heirs in intestacy are objecting to the grant. Probate, will, executor, he makes an application. He may be a beneficiary under the will, he may not be a beneficiary, he may not be also a legatee, outsider. So, the first thing which the court looks into by issuance of citation, that's the reason we have to specify that in case of death in intestacy, these are the persons who would have inherited the estate, and citation is issued to them to make them aware that look here, an application for grant of probate in respect of X has been made. If you have any objection, come forward and state so. If he makes an objection, I will come to this part later on. So, this is the invitation which is made by the court. In case of letters of administration, you have the same provision. You have to issue citation to the persons who are otherwise entitled to the estate as legatee in his intestate death. So, end of the day, citation has to be served. Suppose, as you have given an example, X is the person whose estate is the subject matter of the probate proceedings as also the subject matter of A, proceedings of letters of administration. Now, in probate proceedings, you have to issue citation to the legal heirs of X. Similarly, you will find in letters of administration also you have to issue. So that's where you consolidate. If anyone has to come forward and object, either he can come and say, yes, there was a will, this is a valid will, we know about it, we are agreeable to the grant. Or he will come and say, no, there was no will. Then we will have to fall back to the letters of administration. This is how you have to practically approach the problem. The other part is that what exactly, which is the most important thing, because we often tend to lose track, what is the object of an application for grant of probate or letters of administration from the side of the applicant and from the side of the court. From the side of the court, you should always bear in mind and make this thing absolutely clear that in probate proceedings or in a application for letters of administration, you are not deciding upon the title of the property. You are deciding only on the genuineness of the will. Whether the person who had left behind the will had the testamentary capacity, that is, sound mental state to dispose properties. He was otherwise able to comprehend, understand what he is doing by executing the will, and whether the will has been properly executed in accordance with law. What is the requirement of the will? That has also been spelled out in the Indian Succession Act, which I had referred to. Attesting witnesses should see. So the court will look into this. Apart from this, in respect of probate or letters of administration, the court's conscience has to be also cleared. If there is any suspicious circumstances, you find a will which is apparently validly executed, but there is a suspicious circumstances in respect of execution of the will, an absurd will which shocks the conscience of the court. There, the Supreme Court and other high courts have said the court can, even if the will is proved to be genuine, refuse the grant because of the suspicious circumstances. So you have to also look into this. Now, you are not required to make a roving inquiry as to the suspicious, but if somebody is objecting to that, look here, this will is a product of undue influence, coercion, fraud, then he has to come and prove it. But suppose he proves it, it often happens, you all are judicial officers, the proof, the standard of proof in case of civil matter is not like that of a criminal matter. So you find that yes, there is a prima facie correctness in the assertion made by the objector. Then you have to scrutinize whether the will is really a product of such thing and there is any suspicious circumstances to that. Otherwise, on the proving of the will, we normally tend to grant probate because we are not deciding on the title. Our endeavor is to see if the persons who would have otherwise inherited the estate, whether he or she objects to the will or not. Suppose you take a Hindu will. A Hindu makes a will. Now in the application, there are 3 sons and 2 daughters and the widow. Now 3 of the daughters do not object, 2 of the sons do not object, but widow and 1 son objects that this is not the will. And you tend to gather from the materials, because then what happens, let me also in this part. Now, when it is an uncontested probate proceedings, it is under the Succession Act before the district delegate. Now, if it becomes a contested one, then it is transferred and it will go to the district judge, because the district judge, in case of contested probate proceedings, has the jurisdiction. I do not know exactly the hierarchy in Sikkim, but in Bengal what happens, the district judge then takes it and after hearing it, he may transfer it to the ADJ, who is additional district judge, for the purpose of trial. Maybe the same system is same in Sikkim. Is the system same in Sikkim? Yes? It is taken by the district judge also. Because here number of cases are less, that's the reason, but over there a district judge is having probate proceedings antima numbers, so he has to distribute it. Now then starts the trial. Once the probate application reaches the stage of contentious cause, the moment it is objected to, it becomes a contentious cause. And it remains to be a contentious cause till the caveat is discharged. Now there may be at a subsequent stage, suppose an application is filed, a caveat lodged. Thereafter, the caveator is not pursuing the matter. He or she has not filed affidavit in support of the caveat, putting forth the points of objection. In such a situation, the executor or the propounder can make an application for discharge of the caveat. And if you find there are materials, Supreme Court judgments are there, right from 55 Supreme Court, how caveats are to be discharged. If you find that yes, the caveat is required to be discharged, you can discharge and you can grant the probate, subject to the propounder or the executor proving the will. Now, if there is no such situation, then the application for grant of probate is to be treated as the plaint, and the affidavit or the objections by the caveator caveatrix will be treated as the written statement, and the matter has to be heard as far as practicable as a suit, because unlike a suit under the Code of Civil Procedure where it says that it is to be initiated by a plaint, here it's an application for grant, it's not a plaint. So
Lordship, in that even we'll have to fix issues as well.
no, I am coming to that. Now, when it reaches the stage that it has to be decided as a suit, all the principles analogous to what is followed in case of deciding a suit has to be observed. Discovery, inspection of documents, framing of issues, then every witness action, trial completed, then judgment. Oh, so it will be like a decree. The probate will be like a decree, not ipso facto a decree, but like a decree. Because here also there is a difference in respect of the testamentary and probate jurisdiction. The orders passed by the probate court are orders in rem, and they are not order in personnel. Order in rem means it binds the rest of the world till it's not upset. In a decree, it's a in personam adjudication. It is restricted between X and Y. If it is a regular suit, X and Y who are parties to the suit. So the decree will bind X and Y, not the world at large, but the probate will bind the rest of the world until and unless it is upset. So you have to keep these things in mind while you are hearing a probate application. That what am I doing? Am I adjudicating the title? No. Then what I am doing? I am only deciding as to the authenticity and genuineness of the will. The moment you are bearing, if your thought process, views are clear, there can be no departure from things, and you can easily achieve the goal, because you will find, which we find in our practice life we have done, we tend to mix things. Suppose the father has left a will saying that his property half will go to one son and the rest half will be distributed amongst his other heirs. The other heirs who are getting less share under the will tries to project before the court that look here, this document cannot be construed to be a will because there is a departure from the normal succession, and they tend to raise questions regarding the title. No, The probate court cannot look into the title. The title has to be decided by the competent civil court. If you have issues regarding the will, its genuineness, its authenticity, fair enough, I am there to decide. But if the title is in dispute, go before the civil court, because then you will be transgressing your jurisdiction. See, the court, a district judge, or any court for that matter, wears different hat at different times. When you are hearing the probate proceedings, you are wearing the hat of a testamentary and intestate jurisdiction. While you are deciding, it may be so that a suit has been filed before you, a normal suit regarding title of a land. Then you are wearing the hat of a competent civil court, where you have the powers to adjudicate the right title interest in respect of this. But while in testamentary jurisdiction, you cannot mix up with your right, which may be available to you in normal course, to decide upon the title. So once you can keep this thing in mind, then there can be no deviation from the work which you have been entrusted to do. Now coming to the next part. I have already explained that how the suit, in case of letters of administration also, the same thing has to be followed. If there are objectors, then you have to try it out as if it is a suit, treating the application as plain and objections as written statement. Same procedure. Now, what happens after the probate is granted? See, after the probate is granted, there is a stipulation from the court that the person who has been given the probate has to file an inventory and accounts within a particular time frame. Why this is required? This is required because the ultimate goal of the probate is to distribute the properties and assets to the persons who are otherwise entitled to them under the will. And that is called assent to legacy. First I have to see what are the properties and assets which has come to me as an executor, which are available for distribution. Then I have to give assent to legacy. This is also spelled out in the Succession Act. Assent to legacy. Assent to legacy means, suppose the will says, simple will says that I have 3 children, my wife has predeceased, so these 3 children will get in equal share. The executor, who is not a beneficiary under the will, he will obtain the probate and will distribute 1/3 to each of the children of the deceased. That is called assent to legacy. You will find it in the Succession Act. I will give you the section also. And after the assent is complete, the administration of the estate is reckoned to be complete. Now the executor, after the assent is done, does not remain to be executed any further, because he has, or the administrator, he has administered the estate. Then what is his role? He becomes a trustee. That is the Supreme Court view. He remains there as a trustee because he is answerable to. Suppose today he has obtained a probate and has distributed it. Later on, somebody challenges the grant under section 263 of the Indian Succession Act. If you come to 263, you will find how a challenge can be made. Revocation or annulment annulment for just cause. So if somebody comes and says, look here, I had a caveatable interest, the person who has applied for probate did not mention my name, and that's the reason I was not present before the court at the time when the probate proceedings was decided. I would have or should have been there and ought to have been given a opportunity to state whether I object to it or I support the same. In such cases, there can be annulment. But that also annulment has been specified under what circumstances. Just because you come and say that I was to be cited and I have not been cited, so the will goes, it's not that. You have to come within a reasonable time, you have to show, and all these things will then be considered by the court for the annulment of grant. So, the executor is not discharged, or the administrator is not discharged even though he has completed the administration. He becomes liable as a trustee. If any 263 application is made, he may be asked to answer. That is the reason. Now, in case of citing a person, I go to the next topic. In case of citing the person, in the probate proceedings, if the
Recording is on.
Huh? Oh. Now, in case of probate application or in case of application for letters of administration, as I just now said, the persons who are interested otherwise in intestacy, death in intestacy has to be cited. Now, who are to be cited? The persons who would inherit the property is as per his or her relevant law in the subject. Suppose he is a Hindu, then, or a Sikh, Jaina, Buddha who are covered under the Succession Act. In case of Hindu, his intestate heirs will be as per the provisions of Hindu law. Now, who are the intestate successors? In case of male Hindu, you will find under section 8 of the Hindu Succession Act, read with the schedule, who are the heirs in intestacy. Class 1, class 2, class 3, class 4. Then you will find in section 8, C and D, 1C and D, that if there are no class 1, class 2, class 3, class 4 heirs available, then agnates and then cognates. This you will find if you have a Hindu Succession Act with you. Now you come to section 8. If he is a male, section 8, firstly, upon the heirs, being the relatives specified in class 1 of the schedule, then class 2, class 3, and later on lastly, if there is thirdly, if there is no heir of any of the two classes there, then upon the agnates of the deceased. Lastly, if there is no agnate, then upon the cognates of the deceased. So, in the application for grant of probate, one has to clearly state that in case of whatever application or for probate or letters of administration, he has to clearly say that who are the persons who have inherited the estate in case of death in intestacy. Now, you have to here, as a judge, scrutinize this part. Suppose he says that there is no class 1 heir available of the deceased. Now you turn to the schedule. This is in respect of male Hindu. You turn to the schedule, you will find the heirs of class 1 and class 2 specified over there. Class 1 has one basic content and class 2 has up to 9 contents. So in this fashion, the general rule of inheritance in case of Hindu male will be governed. So suppose I make an application before you and say that look here, there are no class 1 heirs available of the deceased. Then your next endeavor will be, yes, what about class 2 heirs? If he says class 2 heirs, then you have to make an inquiry, who are the class 2 heirs available? So these heirs under class 2 have to be cited, because in absence of class 1 heir, these class 2 heirs will succeed and they have every say when the probate is being granted by the court. They have the right to object or they have right to support. So they have to be cited. Now, in this manner, if say class 2 heirs are not available, then you have to make inquiry whether agnates, and if agnates are not there, cognates. So citation has to be issued in this order. If the class 1 heirs are available, then citation to class 1 heirs. If class 1 heirs are not available, class 2 heirs. Class 2 heirs from clause 1 to clause 9. If none of them are available, then you have to go for agnates. And if agnates are not there, then cognates. If there is no one, then you have to notify the government. Because if you come to section 29 of the Hindu Succession Act, you will find that in absence of any heir, the property will go to the government. Failure of heirs, section 29. In an intestate, if an intestate has left no heir qualified to succeed to his or her property in accordance with the provisions of this act, such property shall devolve on the government, and the government shall take the property subject to all obligation and liabilities to which an heir would have been the subject. In case of Bengal, we have a new act which is called the Estates and Forfeitures Act 2012. where in this sort of situation, the property goes to the government. Previously, the Administrator General used to take charge of the property. Now it goes to the competent authority under the Act of the government. Now, what will be in case of Hindu female? You come to section 15 and 16 of the Hindu succession. The property of a female Hindu dying intestate shall devolve according to the rules set down in section 16. Now you will find it is firstly upon the sons, daughters. This is not in accordance with section 8 of the schedule. In case of female Hindu, it will be under 15 and 16. Now the basic difference over here is that more or less same line of succession. In case of female Hindu, if the property is inherited from her husband's side, then the property will revert back to the heirs of the husband. Now, if the couple had, say, son and daughter, then this question will not further go beyond this because they will inherit. If they do not have, then what will happen? The heirs of the husband, who will be the heirs of the husband then? The class 2 heirs. Because husband is male, husband's succession will be governed by section 8, read with the schedule. In that case, it will be class 1 heirs. If class 1 heirs are there, there is no question of any further inquiry or going into. But if there is no class 1 heirs, then heirs of the husband. And you will find in these two sections, it will be deemed that the husband who may have predeceased her, if the husband is alive, then the property will go to the husband, female, will definitely there will be no further question. But if the husband is dead, then what will happen? He will be considered to be alive immediately at the time of death of his wife, and the succession in terms of section 8 will pass on. So normally if it is from the husband side and there is no class 1 heirs available, then the brothers and sisters, brothers, sons, sisters, sons in like manner. Now under both section 8 and schedule 1 or section 15 and 16, each one in the same entry will take it at once. Suppose a person had 3 brothers and 1 sister who would otherwise qualify under class 2 years in terms of section 8 read with the schedule. Now this gentleman at the time of death has only 2 brothers surviving. 1 brother and 1 sister had died. So his estate will be taken by the 2 brothers who are alive at the time of his death. There is no option under the schedule that the brother's son, the sons and daughters of the deceased brothers will be entitled to a share and will be taking the same along with the surviving brother or brothers. So this you keep in mind while deciding that if we often tend to make a mistake that, look here, he had 4 brothers, so the heirs of the 4 brothers, no, only 2 brothers will get. If you read the section and the schedule bit carefully, it will be clear to you. Now I was on the female succession, female king. Now if the female had got a property from her father, then the heirs of the father would get the property. So in case of an application for grant of probate of a will of a female, you have to also ascertain whether the origin of the properties comprising the estate of the female originated from her husband or came from her father's side. Because then the persons who are required to be cited will be different. In case of properties coming from the father, heirs of the father. In case of properties coming from the husband's side, heirs of the husband. So these are the citations to be made. Then in case of female, as I said, they will be considered to have been alive at the time immediately after the death, and in that manner it will be, if you read 15 and 16, it's all. Now the similar thing is applicable in case of non-Hindu, but that will be according to their own inheritance. In case of, say, Parsis, you have a different sort of inheritance. In case of Muslims, say, Shias have different, Hanafi school has different, Sunnis have different. So who are to be cited? Because in case of probate proceedings, since you are not deciding upon the title, you have to only make an endeavor to bring forth or notify the persons who would have otherwise inherited the property in case of death in intestacy. So if it is the customary law, suppose in case of Sikkim, the customary law is applicable, then under the customary law, you have to ensure who are required to be cited. Same principle, Hindu, if he is a male, these persons are to be cited, female, this sort of citation. Similarly, in case of customary law, but in case of Sikkim, there are judgments which says that the provisions, Indian Succession Act is made applicable to Sikkim. But Hindu Succession Act, there are notifications. So far as I am aware, you are in a better position to say that the application has been suspended. There are some judgments which say that the principles analogous to those in case of Hindu Succession Act may be also followed. Now, if you have a separate customary law, then you have to ensure citation to the persons who would also be there under the customary law. Suppose under the analogous provisions of the Hindu Succession Act, because there are situations in Sikkim which are somewhat tricky. If a Sikkimese marries a non-Sikkimese, then the devolution will be in a different manner. Now, if a Sikkimese male marries a non-Sikkimese female, then it will go in a different manner. If it is otherwise, then it will go in as per the customary law. So you have to make an endeavor that the persons who are required to be cited are cited, otherwise that will be a fault on the part of the court. Now, once they are cited, if he or she does not come forward and object, it is his or her choice. the probate proceedings cannot be later on faltered that look here, I did not get an opportunity, because he was cited or she was cited, did not come forward to either say yes or no. So the court's duty is discharged. Now there you will find, I will give the citation of one of the judgments also, because your customary law is coming into operation. There may be more, but I have been able to find out these few. In respect of your state, there is a judgment delivered by Justice Meenakshi Madan Rai. You must be aware of it. In case of Nil Kumar Dahai and another versus Indira Dahai and others. The date of the judgment is 12th November 2020. Here, in paragraph 67, it has been said, for the sake of repetition, probably you all have read this judgment still. In the absence of any statutory provision dealing with the succession of the state, and as the Hindu Succession Act 56 has not been extended and enforced in the state, but considering that the courts in Sikkim have applied the provisions of law of the country where the law of Sikkim are inadequate or do not cover a specific area, it stands to reason that the provisions of the Hindu Succession Act can be invoked and applied for the purpose of determining the matters relating to succession in Sikkim, involving parties to whom the personal law is applicable till specific laws occupy the field. So unless and until this view is overturned by a higher forum, it still continues to hold good. So you have to take note of this judgment. The other judgment which deals with the such a situation in respect of tribals is a judgment reported in AIR 2013 Guwahati, page 14. Here the learned judge had taken pain to go into the repugnancy, discuss all the issues regarding repugnancy, and then come to the conclusion that here the facts was like this. There was a probate proceedings. Now a jurisdictional issue arose. A point was taken that under the Mizo customary law and the inheritance law of Mizoram applicable to Mizos, the proceedings was to be heard by a council. Now the trial judge had decided in one manner. The High Court, while taking into account all these aspects, says no, even if the 56 Act was there, then also taking into account the provisions relating to the inheritance vis-a-vis the law of land as provided by the Constitution, it is the Succession Act which will prevail. Indian Succession Act which will prevail. So my endeavor is Succession Act will prevail, and in such situations the district judge will be, or the district delegate will be the competent court and not the council. You read this judgment, you will get the discussion on repugnancy. Now so far as we are left with now, we are coming towards the end of the session. So far as the Muslim law of inheritance, yes, you can have your tea, then we can come to the last two parts.
Talking about succession, in case of female Hindu, you said that we have to see also from where the property is called property basically. Now, for example, if a property is a self-acquired property and the female is unmarried, the property has not come from the husband and neither from the father, it is a self-acquired property.
Then the plain and simple answer to come to section 50, first part.
15C, Lordship, it is written, thirdly, upon the mother and the father, or upon the heirs of the father or the heirs of the mother.
Yes, she is a spinster. She neither has a son nor has a husband. So even if it is a self-acquired property, the succession cannot remain in vacuum. So it has to proceed down the line. How it will proceed? It will go, as I had referred to, amongst the heirs, her heirs, that is heirs of the father.
Thank you, Mr. Sorry, in respect of will also, is it necessary to have a medical certificate from the doctor also saying that the person who had executed the will was of sound mind and in full, this thing she had done it, executed it? Thank you.
Any query, any question in respect of the issues which I have till now dealt?
More Lordship, that there is one issue on behalf of Learned. Supposing that particular will, Lordship, the entire property has been given to the testator, objected it. The procedure is, Lordship, whether that particular objection can be separately registered as civil suit vis-a-vis pending probate matter or letter of administration. And how to dispose, Lordship, how to dispose by the, like in Gangtok, Lordship, in our state, the concerned district judges are required to take up that matter, Lordship.
See, I will be answering this question in two, by dividing it into two categories. One, in respect of a will to a stranger, a person in respect of his self-acquired properties, whether he is a mitakshara, he is a dayavaga, he is entitled to bequeath the same as per his own will and volition. So he can give it to a stranger by breaking the normal chain of succession. It may be unnatural but not illegal. Supreme Court, I don't have the present reference now here, but the Supreme Court, as far back in 1976, has clarified that departure from the normal rule of succession cannot be a ground to object to the will if the same is validly executed. So this part is that a person can give his properties to the stranger by a validly executed will. Now, whether the will is valid, genuine, objections are to be sustained, that is obviously part of the trial on the basis of the evidence which is coming forth before the court. So this is one part. Now, the property which is bequeathed, it can be a property which his sons and daughters may say that it is not a self-acquired property, but a property acquired out of the family assets by their father. So, in nature, that property will be an ancestral property and it cannot be bequeathed to a stranger in that manner as sought to be done by the will. If this objection is raised, then they have to file separate civil suit, because I heard in the first session emphasized that which is the hat you are wearing. In probate jurisdiction, the district judge, he is a competent civil court, he is also the probate and testamentary court. So when he is hearing a probate matter, he has to decide on the validity, genuineness of the will. Now if it relates to the property dispute, as per the example you have given, and apropos what I said, then they have to file a civil suit challenge for declaration that the property is not a self-acquired property, but it is a property, ancestral property, which was open to succession as per the relevant provisions of law, and no will could have been made against it. This can be one way. The other way, suppose the sons and daughters come and say that, look here, he has come up with a will by which it appears that my father had given all these properties to him or her, but prior to giving these properties to the person concerned, they had executed document or by a family settlement, may not be registered, oral settlement. These properties had been given to me or to us. So our father did not retain any right in respect of those properties for further bequest after they had given it to us by, say, oral distribution. Then also a civil suit has to be filed, because see, the person who is challenging the unnatural the will only on the ground of unnatural devolution is not likely to succeed. So if he has some issue in respect of the title, he has to file civil suit for declaration of his title and maybe partition or something like that. But he has to file a civil suit. Grateful. Any further clarification?
This, why not the reconciliation cannot be done in same proceeding? Reconciliation or separate the proceeding for civil suit can be done.
See, first thing is that if you go by Booz Allen judgment, later on Bigda Drolia, certain issues are not left for mediation, conciliation, reconciliation. What are these issues? One are issues in rem. Because probate proceeding is in rem, there cannot be any mediation or conciliation in respect or arbitration in respect of these issues. It has been settled by the Supreme Court. Now, reconciliation of the two proceedings.
No, Lordship, not in that this line of section 89. What I mean to say is, Lordship, in lordship, the probate proceeding, if those objection comes, then the Kent district judge segregate that objection and register separately as a civil suit or not? Lordship.
That is not permissible because the district judge then will be transgressing his jurisdiction. He is hearing, or he or she is hearing, a probate proceedings, where, as I had explained, the object is the genuineness of the will, whether it has been validly executed or not. Finish. So far as the title is concerned, it has to be in a civil court of competent jurisdiction. Because I make it absolutely clear that the probate court does not decide the title. Even if the probate is granted, then also title does not flow. So there is always avenues open to persons who are disputing the title under the which has gone under the will, or the title of the properties bequeathed under the will. He or she can file a civil suit even after the probate is granted, and that is maintainable, Supreme Court has said.
Great, Lordship.
So civil suit, in the conclusion is, civil suit has to be filed, and district judge, in respect of the objections raised in the probate proceedings by the legal heirs, cannot segregate them and register a separate civil suit. Separate civil suit has to be instituted by the persons who are disputing the title. Is it clear to all of you?
Yes.
Now we come to a little bit leftover of the first session. Two things. One, if you look at section 300, have you got it? 300? Now this is concurrent jurisdiction. The High Court shall have concurrent jurisdiction with the district judge in exercise of all powers hereby conferred upon the district judge. So, if what happens in Bengal, I tell you, we have the High Court, we have the City Civil Court. Now the jurisdiction, territorial jurisdiction of High Court and City Civil Court is the same. Only the pecuniary jurisdiction of the City Civil Court is less and High Court is more. So, since our High Court is a chartered High Court, having original jurisdiction, suits can be directly filed over there. Now, in respect of probate proceedings, if a person has died within the ordinary original civil jurisdiction of the High Court and all his assets are within, then he has to go mandatorily before the City Civil Court. High Court does not have jurisdiction. But in case of persons who are resident of place outside Kolkata and have left properties both within and outside Kolkata or all outside Kolkata, then the executor or the administrator can directly file a proceedings for grant of probate or letters of administration in the High Court. This structure exactly is not known to me in respect of Sikkim, what is been exactly followed. You people must be better know, but keep in mind that section 300 gives right to the High Court for concurrent jurisdiction, but this has to be notified by the state. There has to be a notification, specific notification passing on the concurrent jurisdiction. Unless this notification is there, the High Court may not be able to exercise the jurisdiction, though under 300 it can ordinarily do. So please check up whether there is any notification granting High Court the jurisdiction to concurrent jurisdiction to entertain probate cases. This takes us to the last part. Now say a probate application or a application for letters of administration has been made before. I will restrict in this particular case to the probate because there is a named executor in the will. Now there is an objection. What is the authority of the executor? If you come to section 302, this is direction which the High Court can give. But if you come to section 303, a person who intermeddles with the estate of the deceased or does any act which belongs to the office of the executor while there is no rightful executor or administrator in existence, thereby makes himself an executor of his own right, own wrong. So there may be cases that the executor has filed a probate proceedings, but during the pendency of the probate proceedings, he is misusing, misappropriating the assets of the estate, which he is required under the statute to preserve for the betterment of the estate and for the purpose of distributing amongst the heirs or the beneficiaries under the law. Now in that case, what the district court has, you kindly come to section 247. Pending any suit touching the validity of the will of a deceased person or for obtaining or revoking probate or any grant of letters of administration, the court may appoint an administrator of the estate of such deceased person who shall have the right and power of the general administrator other than the right of distributing such assets. So, till the probate is obtained, you can appoint an administrator to manage the estate so that the executor named in the will against whom allegations of, say, sequestering the estate or frittering with the estates are there, he can be kept outside the administration. But this administrator will not have the right to distribute because he is not an administrator who is going to get the letters of administration or the probate. is pendentity, administrated pendentity, till the proceedings comes to an end. Now you have another section section 264, which defines the authority of the district judge. So, since you all are part of the judiciary in district judge level, you should verbatimly follow this section which gives you the jurisdiction. And this will minimize any inadvertent transgression out of the jurisdiction. Now, the next section which I will refer to is 283. You were asking, madam, you were asking how the things will be done. You see that 283 gives you, apart from soup, you can also if it's so then kindly come to section 284. I was speaking about the caveats. This is where and how caveats are to be filed and entered. Then kindly come to section 285, you will get how the procedure will continue after caveat has been lodged. Now kindly come to section 307. what are the powers of the executor, and this has to be read in the light whether he misuses the estate, and what steps can the district judge take to prevent such misappropriation. Then kindly come to sections 316, 317. While referring to inventory, I said that inventory is required to be filed. This is the provision under which inventories are required to be filed. Now kindly come to the next part. I had referred to assent by the executor after getting the probate. Kindly come to section 332 onwards. You will get all details about the assent. Now this is what I had to point out to you all regarding the Indian Succession Act, probate, and the formalities to be. Now, one by one, if you have any question, please ask, so that after completing this, I can go to the next topic.
Assent.
Now, assent, what is assent? Suppose, under the will, I had given a brief, I had touched this in brief. Suppose under the will, a person has bequeathed his properties to his sons and daughters. The widow predeceased him. Now, he has named an executor who is not either a legatee or a beneficiary under the will. The executor obtains the probate from the court of the learned district judge. Now, just by obtaining the probate, his responsibilities does not stop, because the whole object is to distribute the asset amongst the persons entitled to them, to complete the effective and complete administration of the estate. Now, he has to then, that's the reason I showed, he has to file an inventory, and then by way of document, registered, it may be registered, it may not, registered documents are better, to show before public at large, if it is questioned. Suppose you are entitled to a house under the will. I am the executor. I have to execute a document that pursuant to such and such I have obtained the will. Under the will, this property is to go to you. I am handing over this property to you. Then it will be signed by you and me. It becomes an authentic document for giving the asset. That means the desire of the deceased, that is testator or testatrix, is carried out. He or she wanted it to go to their children. It has been made over to or distributed to the children. This is what is assent. Now there may be a case that the executor himself is a beneficiary under the will, and there are other beneficiaries. Then so far as giving assent to the other beneficiaries document, and in respect of him, you will find there is a provision, assent to the specific legatee given to the executor. So he has to also put it on record, look here, this is the property which I am entitled to get under the will. As an executor appointed under the will, I have obtained the probate, and after obtaining the probate, I have distributed all properties amongst the persons entitled to by way. This was the property left over, it has to come to me, I now accept this property. This is how the assent has to take place. So that at a later stage, no confusion evolves regarding the effective and proper administration of the estate. This is very similar to what we have in case of movables nominee. Suppose under a fixed deposit made in a bank by a person, you are appointed the nominee. What is your role? Your role is to collect the money and distribute it amongst the persons who are under the general rule and law entitled to receive that money. Similar is the role of the executor. Yes, any further question?
Grateful, sir.
Yes? Yes, madam, do you have any question? You are free to ask. No one will be questioning you. Why did you ask?
I
Don't,
have.
don't,
I don't have.
don't get scared that your colleagues or
I'm not.
juniors may say
I'm
that,
not sorry.
that you have asked a question.
Actually, I have one question.
Yes.
Suppose a property, some of the portion of the property is in other state, perhaps in West Bengal or Delhi or somewhere else. The major portion is in Sikkim. Will the district judge of Sikkim, let's say Gangtok, have the power to probate the will,
Yes.
including the properties of
Yes. You have a specific provision for that? You come to subsection 3 under section 276. Have you seen that? You have to state. So you have let us take a simple case in a civil suit. If say there are several properties of which out of 10 say 6 are in the Sikkim jurisdiction, district judge say Gangtok. Then 4 are say at Darjeeling and 2 are now at Kalimpong. So the courts at Darjeeling, courts at Kalimpong and the court at Gangtok has the jurisdiction. Now a person can choose any one of them, but he has to say that yes, these are the properties, these are within. So part of the properties are within. So you have the jurisdiction as you have the right to adjudicate in respect of this. Instead of filing 3 suits in 3 separate districts, it can be consolidated and filed in one district. That is what exactly in case of probate. Though not in the same line, because then you will find in the probate application you have to get documents from the court, whether it is in respect of issuance of the grant in respect of the whole of India, or it is restricted only to Sikkim, or say restricted to the state of West Bengal. Those certificate declarations are ought to be obtained and given. forms part of the probate application. Yes. Sir, you have been noting down. Don't you have any question? Yes, madam. Yes. ACJ. Madam, you don't have any query. That means I have not been able to properly make you understand. Otherwise, there ought to have been queries. Yes, any query?
No, Lordship, I think absolutely, from your Lordship side, everything is clear there, Lordship. There is no grievance side from the side of officer. Lordship may kindly proceed ahead so that we can. Lordship.
Very good. Now, I was in this section referring to also Muslim succession. If you look into the Shia rules of inheritance as described by Mullah, you will find what Mullah has said. The Shias divide heirs into two groups. One, heir of consanguinity, that is blood relations, and two, heirs by marriage, that is husband and wife. On the basis of this, in case of Shia, the inheritance has been divided into three classes. First is parents. Second is children. This is under one. Under one, parents, which is Roman capital 1 and small 1. Then II under 1, children and other lineal descendants. Then 2, grandparents. Then 3, brothers and sisters and their descendants. Then paternal, maternal uncles and aunts, and his parents and grandparents and their descendants. Of these three classes of heirs, the first excludes the second class. So, when parents are there, subsequent classes are eliminated. Similarly, when parents or children are not there, then grandparents come, and that eliminates, if the grandparents are there, any subsequent follow-up. And this goes on up to the paternal and maternal uncle. Now, in case of probate, because some of the Muslim probate applications come within the purview of the Indian Succession Act. There you have to ensure that citation is issued in the order of inheritance in case of Shias, if the deceased is a Shia, so that later on no one can complain that I have not been cited. Now, in case of Sunnis, there is a different line of inheritance. If you look into it, you will find, and the endeavor will be to cite the others. Now, so far as Christians are concerned, they are, under the Indian Succession Act, there are two categories of Christians. One who are Indians, native, and they have continued, and there is no change in their inheritance by way of marriages. The other are the Christians who have later on come to, say most of them had come during the British regime. So in those cases also Indian Succession Act is applicable. So you have to follow the provisions of Indian Succession Act so far as it applicable, because if you read it carefully you will find which are the chapters which are applicable in respect of whom. Because you will find that a particular chapter is applicable to Hindus but not to others. Similarly, other chapters are there. So you have to follow which chapter, under which chapter you are adjudicating the issue, and then what will be the course. Keep this in mind. I don't think much of difficulty will take place. Now let us go to the second stage. The second session is joint family property and partition in Hindu law. Now I have touched this to some extent. Under the Hindu Succession Act, you will find two class of Hindus. One is Mitakshara school of Hindu law, which is all over India except Bengal, and in case of Bengal, Dayabhaga. Now the succession in case of Mitakshara and Dayabhaga is somewhat different. Why I say so? In case of Mitakshara, though it is termed as birth, but Supreme Court has clarified that with the conceivement of a child in womb, he gets a share in the ancestral property. Now, the Coparcenary in case of the Mitakshara spreads over fourth generation. Suppose X is the first man, so his son, and his son. So father, grandfather, great-grandfather and great-great-grandfather. This is the 4 degrees which will come. Now A, let us take X is the person. Now A is his son, B is his son's son, C is his son's son. So each of them will have a share in the coparcenary property, that is Hindu ancestral joint property, and this is by way of survivorship. Why I say so? I say so because of the judgments and also the elucidation in the book. Now, how does this coparcenary property devolve? This coparcenary property devolves with the birth or conceivement. Now, prior to (2005) amendment to the Hindu Succession Act, the properties would travel from the male Hindu to the male Hindu only. The basis was that a female who is from that particular family on her marriage becomes part of the other family, and as such is not allowed to give offerings to their ancestors. On this broad concept, only the females were able, but after the 174th Law Commission, several rounds of discussion, and ultimately the female has been given the same right as a male in case of Mitakshara family, with the exception that if there has been already a partition, then she will not be entitled to get anything or seek further partition. But if it is not partitioned, then she can claim a partition and her separate right on the strength that on her birth she got a property, she got a share in the ancestral property. Now a person, as I was giving example X, he may have ancestral properties, he may have self-acquired properties. So far as the ancestral properties, the succession is by survivorship. So far as ancestral, he has the right to dispose of the property, he has the right to give it to somebody, and at the same time, under the normal law of inheritance, his sons and daughters, his widow if alive, would get a share in the property in case of his death in intestacy. But in reality, what happens when the court is placed into such a circumstance? Because by this time several partition suits have come before you. There are specific claim or case made out in the partition suit. Look here, my great grandfather had this property. This is ancestral property, of which by way of survivorship I have this right. These are the properties which my father acquired out of his self income. These do not form part of the Coparcenary. As his legal heir, I am entitled to such and such share in those self-acquired properties. And in this form, partition is sought for. Then what will be the endeavor of the court? The endeavor of the court will be to first look into whether the allegations are correct or not. In order to do so, you have to scrutinize the origin of the property which is alleged to be a coparcenary property, and that there has been no partition already effected in terms thereof. Then what you have to do? You have to ascertain whether the properties which are claimed to be self-acquired properties are actually self-acquired properties or properties acquired out of the family funds, family business. You have to also make an inquiry whether the self-acquired property claimed in this suit is actually a self-acquired property which is open to be divided amongst the normal heirs. Unless you do this exercise, you will be faltering in granting in proceeding with the trial and granting the relief as the end result. Why I say so? If it is a coparcenary property, then its inheritance will be by way of survivorship. The example which can be given, say A had two sons. When these two sons were born, A had, say, one property. I am taking example of one property. A had one son, one property. A had full share in the property. Then with the birth of his two sons, then the sharing the property becomes 1/3 to A, 1/3 to his one son, 1/3 to his other son. Now these two sons after marriage has, say, one has 3 sons and one have 2 sons. So again these 3 sons and the 2 sons, total 5, on their birth will have a share in the property. So 1/3 share which was available to one of the son will now get reduced. Similarly, 1/3 available to the other brother will also get reduced. In this manner, the shareholding of the persons being co-parceners in the estate is decided or adjudicated. Number of heads who are born and how it is distributed or divided. Similarly, say the property is not an ancestral property, then the devolution will be under the normal law. There, by way of survivorship, by birth, each will not get. Straight away, father's property, 2 sons on father's death will have 50% shares, and the sons and daughters of the son together will take 50% and vice versa. So the accrual of share by birth is not available in case of normal ancestral property. In case of self-acquired property. So this, unless you can be sure of the distribution, you cannot proceed with the suit, because you have to frame the issues, then you have to hold a trial on the basis of the issues, and your focus will be to identify these things so that at the end you do not falter in delivering your judgment. There may be another scrutiny or inquiry. Suppose I say that these are the self-acquired properties of my father. There may be somebody else canvassing, no, these are not self-acquired properties of the father, but they are acquired, accumulated from out of the family funds. So this has to be treated as joint property or a coparcenary property. Then, unless you hold this enquiry, your end decision may be faulty. So, you have to first ascertain the origin of the property, then how it will devolve, and at the end who will be having what share. Now the next point is, I covered the first point, that is joint family property and the partition in Hindu law. Do you have any query or any question in respect of this, so that by answering it I can move further?
Let's say this small clarification. So, what has fallen from your lordship is whole qualified geological chart is required to declare any property of Hindu as ancestor property.
Yes.
And after qualifying this four layer of generation lordship, if that particular property is divided, then that particular property holder can declare that property as a self-acquired property. Or if after distribution or during distribution, any one of the legal heirs was in home, and again that particular upcoming legal heirs can claim that property, saying that no, the distribution has already been done, but I was in home, so therefore that particular property cannot be a self-acquired property. Third is lordship, how long that particular layer keep on going on to declare any property as ancestor property. Suppose like son, grandson, great-great-grandson, great-great-grandson, how many layers lordship required to be qualified, and how long it will go, lordship?
Four generations. Fourth generation. Grandfather, son, son's son, and son's son's son. This is the way it will go, the structure. You will find it, if you look into the Hindu law authored by Mullah, you will find there are charts given which will clearly show
Four generations.
what I have just now said. Now, more important, apropos your question, is to verify the origin of the property. See, self-acquired property is what? Which you earn. Which are those properties? Suppose you acquire out of your own income, and it has no nexus with your family income or acquisition through family assets. Suppose the estate is father, son, son's son. Now, the father has a property which he acquired. The initiation of this property may be from out of his income. Initiation, because see, it has to start from a particular point. A property has to come into existence. So, it may so happen that he had acquired the property out of his income. but he had put this property as a joint property. So even if it is acquired out of the self income proceeds, still then that property can be thrown into the hodgepodge of the family properties so that it can be treated as an ancestral property.
Lordship, what clarification I want is, Lordship, after distribution of ancestor property, it will remain ancestor property forever? Or it will,
No. The,
for
the
incoming offspring, Lordship?
The moment, suppose there is a partition. After the partition, you get a family property in your hand. Now this family property which will come to you, if your sons and daughters, this is a bit complicated part of Mitakshara law, because it provides that the father can separate from his sons but remain joint with his grandson. So you have to look into the aspect where the chain breaks. Now if the sons say X, he has two sons. Now in the hands of X, there are ancestral properties, there are self-acquired properties. Now when it comes to the son by way of partition, he gets a share both in the ancestral property as also father's self-acquired property. Now these two intermingled together will come to him as his ancestral property. Am I able to make it clear?
Yes, Lordship.
Take an example, as I was giving, you had a property, say this building, as your ancestral property, in which with the birth you had a share. Then you have certain properties which you had acquired by your self-income. Now these two properties will remain separate in your hands, because the distribution of these two classes of properties will be in a different mode. You have, in respect of the ancestral property, you have yourself a share, your sons on birth, sons on birth up to 4th generation. So you may have 10 co-sharers over there. But in respect of self-acquired properties, you will be having only 2 co-sharers, that is 2 sons of yours, not the grandsons, because your property under the Hindu Succession Act will go to your children, not to your grandchildren directly. If you look at the schedule of the Hindu Succession Act, Section 8, read with this schedule. in class 1 here, son, daughter, widow, mother. Son of a predeceased son. Only if the son is not available, then the predeceased son comes. But the grandsons, where the son is alive or are alive, will not under normal inheritance get any property. So the self-acquired property will be distributed in this normal rule of inheritance. That is, his sons, his mother and the widow will get shares. But grandsons, in the presence of the sons or granddaughters, will not get any property, any share. Now these two, when it comes to your comes to the hand of your son, that is a share from the ancestor property, that is coparcenary property, as per the survivorship ratio, and that out of the self-acquired property will then intermingle to form the estate of your son, wherein again 4 generations from him will have a share in that ancestral property, coparcenary. While his self-acquired properties will again be distributed amongst his son, then mother and widow, son or daughter, whatever will. Again, your son will have 2 sets of properties, one which is ancestral and the other which are self-acquired. Same way of distribution then and there. Is it clear?
Yes.
Now, devolution of interest in coparcenary property. This I have already discussed in reference to the previous topic, how the devolution takes place. The question which you had put forward, I have clearly given the examples. So, any further questions on that?
I think Lordship, no question.
Now, then provision of granting and revoking probate and letters of administration. This now you come to section 260, which I had already referred to. Have you all have come to 263? Revocation and annulment. The grant of probate or letters of administration may be revoked or annulled for just cause. Then certain examples are set out. A. The proceedings to obtain grant was defective in substance. Suppose the court assumed a jurisdiction which was not available to it and had granted the probate. Then it can come under clause 1. Substantive proceedings to obtain grant were defective and defective in substance. Similarly, if the rightful persons were not cited, then it is a substantive lack to the procedure to be followed. Then you come to B. Grant was obtained fraudulently by making a false suggestion or by concealing from court something material to the case. Now this you all are aware as judicial officers that if there is a suppression of fact, I will refer to the two judgments of Justice Hon'ble of the year 2003 and 2004, where the suppression has been, what nature of suppression has been clearly elucidated. The suppression has to be such that if it was brought to the notice of the court, then the order which has been passed would not have been passed. So probate granted on assumption of certain facts. But something was concealed from the court, which if it was known to the court, then the court would not have granted the order, here the probate. So in such a case, it can be annulled. Then C. The grant was obtained by means of untrue allegation of fact essential in point of law to justify the grant, though such allegation made in ignorance or inadvertently. If the whole gamut of the proceedings for making some statement is altered, then it comes under 263. I give you an example. In a application for grant of probate of a Hindu female will, it is not stated about the origin of the property, whether it came from the husband's side or from the father's side. Then the court where the property has come from the father's side will may be persuaded to treat that it has come from the husband's side, and by applying incorrect legal provisions, the probate will be granted, because in that case you have to cite the father's heirs, in the other case you have to cite the heirs of the husband. In case of property where heirs of the husband were required to be cited, you are persuaded on the factual matrix brought before you to cite the heirs of the father or the vice versa, then it is gone. Then grant has become useless and inoperative through circumstances. Suppose the property itself has gone. Somebody had obtained grant, but at that point of time when the grant was obtained, but at the point of time when the will was executed, the testator or the testative had sold out the property. Suppose this building is the subject matter of a will, along with other buildings. Now, the testator or the testatrix, prior to his or her death, has sold out this property. Now, this is no more in existence. Then what will happen if I grant a will? Nothing will effectively take place, because the subject matter of the bequest is not there. That is the reason where this preservation of the asset comes, because you have to foresee that the assets forming part of the estate has to be preserved, protected for the ultimate distribution to the beneficiaries. That's the reason, because during the pendency of the probate, if the property goes, then what will you grant and how will be the grant made operational? Then come to E. Persons to whom the grant was made has willfully and without reasonable cause omitted to exhibit as inventory or account in accordance with the provisions of chapter 7 of this part, or has exhibited under the chapter an inventory or account which is untrue in a material respect. So this I had already touched. To further elucidate that inventory why required, because these are the properties pursuant to the grant of probate has come to the hands of the executor. You will find in probate proceedings there is a provision for filing of affidavit of assets. What are the assets which the deceased had and what has actually come to the hands. On that basis the inventory is done and the ultimate distribution takes place. So if these things are in question, then under 263 you can annul the grant or set aside the grant. Yes, anything further? See, I have been able to finish it 15 minutes prior to the scheduled time. Then there may be a doubt that whether I have actually covered all the topics or not.
Worship, you've covered everything.
I think so, but it may be construed in a different manner. Yes.
You were saying that you will be giving us case law with regard to section 263.
Section?
Case law?
Section 263. Unfortunately, I have not got my copy, but 263 cases are available. The recent case, which I understand, is 2021. Some cow was titled is cow of Supreme Court. Yes. You are asking something?
Hon'ble Justice Rumapal's judgment.
That is suppression, 2003. SPS or SMS, something like that. SPS. I can give you, if you want, I can give the citations. I will send it to all the citations. No difficult. Now, one important thing which is not covered under the topic, but I think you should know. Tell me, all of you, be attentive, tell me, is there any application of Limitation Act in case of probate proceedings? Is there any application of Limitation Act in respect of an application for grant of probate or letters of administration?
I don't think so, Lordship.
Lordship, this probate under section, this Indian Succession Act 1925 deals with movable property only, Lordship. So therefore, that 3 years of filing, 3 years limitation, Lordship, second, Article 58, 57, 58.
Do you have Supreme Court cases in your library?
Lordship.
You get 2008, volume 8.
If pleases to just a little bit highlight on this Dayabhaga school also, Lordship. Sometimes the petitioner residing here may have property in Calcutta also, Lordship, and choose to file.
See, Dayabhaga is in respect of persons domiciled in Bengal. Suppose a person who is Mitakshara, he may have properties in Bengal, but it has to be decided in terms of Mitakshara school. Yes. The judgment is reported in 2008, 8 SCC 463. See, paragraph 14 and 15, I am reading it out. Though the nature of the petition has been rightly described by High Court, it was not correct in observing that the application for grant of probate or letters of administration is not covered by Article 137 of the Limitation Act. Same is not correct in view of what has been stated in a judgment has been reported. Then similarly, reference was made to a decision of Bombay High Court in such and such, rejecting Mr. Dalpatra's contention. I summarize the conclusions thus. Under the Limitation Act, no period is advisedly prescribed within which an application for probate, letters of administration or succession certificate must be made. The assumption that under Article 137 the right to apply necessarily accrues on the date of death of the deceased is unwarranted. Such an application is for the court's permission to perform a legal duty created by a will for recognition as a testamentary trustee and is a continuous right which can be exercised any time after the death of the deceased, as long as the right to do so survives and the object of the trust exists, or any part of the trust, if created, remains to be executed. The right to apply would accrue when becomes necessary to apply, which may not necessarily be within 3 years from the date of the defendant's deceased death. The delay beyond 3 years after the deceased death would arise suspicion, and greater the delay, greater would be the suspicion. Such delay must be explained but cannot be equated with absolute bar of limitation. Once execution and attestation are proved, suspicion of delay no longer operates. Conclusion H is not correct. Conclusion B is not correct. While conclusion C is the correct position of law. Or what is conclusion B? The assumption that under Article 136 right to apply necessarily accrues on the date of death of the deceased is unwarranted. That is incorrect. C. Such an application is for the court's permission to perform the legal duty created by the will or the recognition of the testamentary trustee, and is a continuous right which can be exercised at any time. So, the explanation of the delay has to be given. You may come after 3 years, but one has to explain why the delay occurred and suggest cogent grounds for the court's consideration.
Yes, grateful, Lordship.
So, with this, I think we can end this session also. Anything further?
Lordship, that Dayabhaga still remains, Lordship, yes.
Dayabhaga.
Lordship.
See, in Dayabhaga, there is no coparcenary property. The Dayabhaga property is treated to be the self-acquired property of the person concerned. Now, as I had explained, in case of Pitakshara, there may be a coparcenary property, there may be a self-acquired property. But in case of Dayabhaga, all are treated as self-acquired property. So the inheritance in case of Dayabhaga will be in accordance with section 8 strictly, read with the schedule in case of male Dayabhaga and in respect of females under 15 and 16. So there is no question of any devolution of interest by survivorship. By survivorship. It is open for being distributed amongst the heirs under the Hindu Succession Act. Grateful. All for the cooperation you had rendered. I think the interaction session was also quite good. Thank you all.
Thank you.
Thank you.